My name is Renata Voss. I am 31 years old. And the week my stepfather tried to have me declared legally incompetent to manage my own inheritance, he was using a power of attorney I had never signed. Welcome to Quiet Ledger. This is the channel where the paperwork tells the story that the family spent years trying to bury. If you have ever been the most capable person in a room that kept pretending you were the most fragile, this one is for you. Drop a comment. Subscribe. And stay with me, because this story takes a while to land, and the landing is worth it. I should tell you what I do for a living, because it matters to everything that follows. I am a licensed forensic accountant. I work for a mid-sized firm in Columbus, Ohio, and my specialty is tracing money through structures that were designed to hide it. Shell companies, layered trusts, intercompany loans that never get repaid. I spend my days reading documents that were written to be misread. I find the number that does not reconcile. I find the signature that does not match. I find the date that cannot be right because the person who signed it was somewhere else that day. I am very good at this. My supervisor, a woman named Doris Hecht, who has been doing this work for 26 years, told me once that I have a gift for reading what a document is trying not to say. I took that as the highest compliment anyone in my field could receive. The problem is that I spent the first 28 years of my life applying exactly none of that skill to my own family. I read everyone else's numbers with a cold eye and read my own family's story with the warmest, most forgiving eye I had. That is the thing about the people who raised you. They get the version of you that hasn't learned to be careful yet. Let me tell you about the blue folder. Not the one I brought to the meeting, though that one matters too. The first blue folder. My mother kept it in the second drawer of her roll-top desk in the study of the house on Aldermore Lane in Westerville, Ohio. It was a standard letter-size folder, the kind you buy in a 10-pack at an office supply store, and it had a white adhesive label on the tab that read, in my mother's handwriting, Renata, Medical and School. Inside it were my immunization records, my report cards from kindergarten through 12th grade, my social security card in a small paper sleeve, and a single sheet of paper that I did not understand until I was 23 years old. That sheet of paper was a one-page summary from a child psychologist named Dr. Elaine Marsh, dated October of 2002, when I was 8 years old. It said, in clinical language, that I was a highly functioning child with no developmental concerns, strong verbal reasoning, and above average capacity for abstract problem solving. It said I was, in the doctor's words, exceptionally self-directed for her age. My mother had taken me to that appointment because my stepfather, Warren Voss, had told her he was worried I was, quote, too intense, too focused, too much in my own head. He had wanted the psychologist to find something wrong. She had not found anything wrong. He had never mentioned that appointment again, but my mother kept the report in the blue folder. And years later, when I finally understood what Warren had been trying to do at 8 years old, I understood why she kept it. She was keeping the evidence. She just never told me she was doing it. That detail matters later. Hold on to the blue folder. I need to give you the full picture of Warren Voss before I give you the events, because Warren is not a cartoon. He does not raise his voice. He does not slam doors. He is 63 years old, a retired civil engineer, and he has the kind of calm, measured manner that makes people in waiting rooms and church lobbies describe him as a real gentleman. He wears collared shirts on weekdays and brings casseroles to neighbors when someone dies. He coached my half-brother, Elliot's soccer team, for 4 years. He shakes hands firmly and remembers names. If you met him at a dinner party, you would like him. You would trust him with your car keys. You would not think to check whether he had already made a copy. Warren's particular skill, the one I did not name until I was an adult, is that he operates entirely through paperwork and process. He does not threaten. He files. He does not argue. He documents. He does not take things from you directly. He creates structures that make it look like you gave them away. That is the kind of adversary that is almost impossible to fight until you learn to read the same language he writes in. I spent 28 years learning that language professionally. It took one more year to turn it around and point it at home. My mother, Claudia, married Warren when I was 4 years old. My biological father, Marcus Osei, died in a construction accident in the spring of 1998. He was 32. I have 3 photographs of him and a memory that is more feeling than image. The weight of a hand on the top of my head, the smell of sawdust, and something citrus. My mother was 29 when he died, working as a dental hygienist, raising a 4-year-old in a 2-bedroom apartment on the east side of Columbus. She met Warren at a church potluck. 14 months later, he was steady. He was employed. He was present in a way that my mother, exhausted and grieving, needed someone to be. I do not blame her for marrying him. I understand it completely. What I did not understand for a long time was that Warren had understood something about our family from the very beginning that the rest of us had not yet seen. My father had left me something, not much, by some measures, but enough, by Warren's. Marcus Osei had a small life insurance policy through his union, $50,000. My mother received it after his death, and she did what she thought was the right thing. She put it in a custodial account in my name, earmarked for my education or my future, whichever came first. She told me about it when I was 12, sitting at the kitchen table on a Saturday morning, the kind of Saturday that smells like coffee and dish soap. She said, "Your father left you something. It is yours when you turn 25. I want you to know it exists." I said, "Okay." I did not fully understand what it meant. I went back to whatever I had been reading. My mother folded her hands on the table for a moment. Before she got up, I remember that. The folded hands. I did not know then that Warren was in the hallway. I did not know. He had heard every word. I know it now because of what happened in the 16 years that followed. If you have ever watched someone work slowly and patiently toward a goal that you did not know they had, you understand how invisible that kind of harm is until it is complete. Warren did not move quickly. He moved the way a glacier moves, a fraction of an inch at a time, reshaping the ground beneath you while you are busy living your life on top of it. The first thing he did, and I only reconstructed this later from documents, was position himself as the account's informal manager. My mother trusted him with the finances. She was working full-time, raising 2 children, and Warren was the one who handled the paperwork. He was an engineer. He understood accounts and interest rates and annual statements. She handed him the folder, the same way you hand someone the car keys when you are tired and they offer to drive. She did not know. He had already decided where they were going. The second thing he did was begin, very gently, very consistently, to build a narrative about me, not a cruel narrative, a concerned one. Warren was always concerned about Renata. Renata was so intense. Renata had trouble with relationships. Renata made impulsive decisions. Renata was brilliant. Of course, everyone agreed on that. But brilliance without stability was its own kind of liability, wasn't it? He said these things at dinner tables and in church lobbies and in quiet conversations with my mother that I was not present for, but that my mother, years later, would describe to me word by word from memory. He was never unkind. He was never wrong about any single fact. He simply arranged the facts in a frame that made me look like someone who needed managing. And he said it so consistently for so many years that people began to believe it, including, for a while, me. I want to stop here for a moment. If you have ever had someone in your life who expressed their control as concern, who packaged their management of you as worry for your well-being, who made you feel that every boundary they drew around you was for your own good, I need you to hear this. That is not love. That is administration. Love does not require you to be smaller to function. Administration does. Stay with me. This is where the pattern starts to have a shape. I left for Ohio State at 18 on a partial academic scholarship. I studied accounting because numbers had always made sense to me in a way that people sometimes did not. I was good at it immediately, not in a flashy way, in a quiet, methodical way. I found errors that other students missed. I understood the logic of a balance sheet the way some people understand music. Not just the notes, but the structure underneath the notes. The reason one thing follows another. My advisor, a professor named Dr. Gerald Fenn, told me in my junior year that I should consider forensic work. He said I had the temperament for it, patient, precise, and, he said, you do not get rattled when the numbers are ugly. I did not know then that he was describing a skill I was going to need at home. I graduated in 2015, passed my CPA exam on the first attempt, and started at the firm 8 months later. I was 22 years old, and I had never been happier. I called my mother every Sunday. I visited for holidays. I was polite to Warren. I was good to my half-brother Elliot, who was 15 and going through the specific misery of being 15, and who I genuinely liked. I was, by every external measure, a functional adult with a good career and a manageable family situation. I had no idea that Warren had spent the previous 18 years building a structure around my inheritance that was designed to outlast my mother's trust in me. I turned 25 in March of 2019. The custodial account was supposed to transfer to my name automatically at that point. That is how custodial accounts work. The custodian, in this case, my mother, releases the funds to the beneficiary upon the beneficiary reaching the designated age. It is not complicated. It is paperwork. I know this because I work with these instruments professionally. I called my mother the week before my birthday and asked about the transfer. She said she would look into it. She called back 2 days later and said Warren had mentioned there might be a small administrative delay, something about the account being moved to a different institution a few years earlier, but that it would be sorted out within a few weeks. I said, okay. I trusted her. I went back to work. A few weeks became 2 months. 2 months became 6. I called again in September. My mother's voice had a quality I had heard before. the quality of someone repeating words that were given to them. She said Warren had spoken to the account manager, and there was a question about the original custodial agreement, something about a clause related to the beneficiary's financial stability, and that it might need a legal review before the transfer could proceed. I said, "What clause?" She said she would have Warren explain it. Warren never called. That was the first time I opened a new note on my phone and started writing things down. Date: September 14th, 2019. Mother says there is a clause. Warren has not called. I did not know then that I was starting a ledger. I know it now. Here is where I need to introduce you to someone. Her name is Priya Subramaniam. She is 34 years old, a civil litigation attorney, and she has been my closest friend since we were assigned to the same orientation group at Ohio State in the fall of 2011. Priya is the kind of person who listens the way a good doctor listens, not waiting for you to finish so she can respond, but actually tracking what you are saying, filing it, cross-referencing it against everything you have said before. She is also the kind of person who, when you tell her something that sounds wrong, does not say, "That sounds wrong." She says, "Tell me the exact words they used, because the exact words are where the problem lives." I told Priya about the account delay over dinner at her apartment in October of 2019. I told her about the clause my mother had mentioned. I told her that Warren had not called. Priya put down her fork. She said, "Renata, what institution is the account currently held at?" "What S?" I said. "I did not know." She said, "Find out." That is the line I will remember for the rest of my life, not because it was dramatic, because it was the exact right question, asked at the exact right moment, by the one person who understood that the answer was going to matter. I found out. It took 3 weeks and 4 phone calls, and 1 written request submitted under my name as the named beneficiary of the account. The account had been moved in 2016 from the original institution, a credit union in Columbus, where my mother had opened it in 1998, to a private wealth management firm in Cincinnati called Alderton and Associates. The move had been authorized by the custodian of record, my mother, except when I spoke to my mother about it. She said she did not remember authorizing a transfer to Cincinnati. She said she might have signed something. Warren handled the paperwork. She trusted him. I asked her if she still had the paperwork. She said she would look. She called back 3 days later and said she could not find it. I said, "Mom, I need you to request a copy of the authorization from Alderton and Associates." She said she would ask Warren to do it. I said, "Mom, I need you to do it, not Warren. You, you." There was a pause. She said, "Okay." She did not do it for another 6 weeks. When she finally did, the authorization on file at Alderton and Associates bore her signature. But the date on the document was a Saturday in August of 2016. I know, that Saturday. I have the receipt. My mother and I drove to Cincinnati that Saturday to visit her college roommate, who had just had knee surgery. We were gone from 7 a.m. to 9 p.m. We ate dinner at a restaurant called the Ivory Fork on Montgomery Road. I paid with my debit card. The receipt is time-stamped 6:47 p.m. My mother was not in Columbus on that Saturday. She could not have signed a document in Columbus on that Saturday, but the document said she did. That detail is the first brick. Hold on to it. I want to be precise about what I did next, because the order matters. I did not call Warren. I did not call my mother with accusations. I did not post anything. I did not tell anyone except Priya. What I did was open a new folder on my laptop, label it account review, and begin building a timeline. I am a forensic accountant. This is what I do. I requested the complete account history from Alderton and associates under my rights as the named beneficiary. Ah, they sent it. I requested the original custodial agreement from the credit union. They sent a copy. I requested my mother's bank records for August of 2016, which she gave me access to voluntarily when I explained, carefully and without alarm, that I was trying to reconstruct the transfer history for tax purposes. She trusted me. I was not lying to her. I was just not telling her everything yet. The picture that emerged from those documents took me 4 months to fully assemble. When it was assembled, it looked like this. In 2016, Warren had moved the account from the credit union to Alderton and Associates using a document that bore my mother's signature, but could not have been signed on the date it claimed. The account at Alderton was structured as a discretionary managed trust, which meant the trustee, listed as Warren Voss, had broad authority over investment decisions and distributions. The original custodial account had been straightforward. At 25, the funds transferred to me. The new structure at Alderton had no automatic transfer provision. Distribution required trustee approval. Warren had replaced a simple custodial account with a structure that gave him permanent control over whether I ever received the money. The account balance in January of 2020, when I completed my timeline, was $68,400. The original $50,000 had grown over 22 years. Warren had not stolen the money. He had simply built a door around it and kept the only key, and he had done it with a signature that was either forged or obtained under circumstances that did not match the date on the document. I sat with that for a long time. I did not cry that night. I made a cup of tea and sat at my kitchen table and looked at the timeline on my laptop until the screen went dark. Then I went to bed. I did not sleep well, but I did not cry. Not yet. The crying happened 3 weeks later, on a Tuesday evening, in my car, in the parking garage of my office building. I had just come from a client meeting where I had spent 2 hours explaining to a family how their business manager had restructured their assets in a way that looked like estate planning and functioned like theft. I had explained it calmly, with documents, the way I always do. I drove to the parking garage. I sat in the car. And then something in me understood, fully and completely for the first time, that I had been that family, that I had been sitting across the table from my own case for 28 years and had not seen it because the person doing it was someone I had eaten breakfast with and called dad for most of my life. I cried for about 12 minutes. Then I wiped my face, started the car, and drove home. I have not cried about it since. Some things you are only allowed to grieve once before they become evidence. I need to tell you about the letter, because the letter is what changed the timeline from a personal investigation to something that required immediate action. In February of 2020, 8 months after I had started my account review, and 4 months after I had completed my timeline, I received a piece of certified mail at my Columbus apartment. The return address was a law firm in Westerville, Ohio, called Hargrove. The letter was addressed to me. It informed me that Warren Voss, acting as trustee of the Renata Osei Voss Discretionary Trust, had initiated a petition in Franklin County Probate Court to extend the trust discretionary period by an additional 10 years on the grounds that the beneficiary, meaning me, had demonstrated Quote, a pattern of financial instability and impulsive decision making that made immediate distribution contrary to the trust's purpose and the beneficiary's own interests. The petition cited three pieces of supporting evidence. First, a credit card balance of $4,200 that I had carried for 6 months in 2017 while paying off my student loans. Second, a personal loan of $8,000 I had taken in 2018 to help a friend cover a medical emergency. Third, a notation from a financial wellness evaluation that I had apparently undergone in 2019. I had no memory of this evaluation. I had never consented to any financial wellness evaluation. I had never signed anything authorizing Warren to commission one. The letter gave me 30 days to respond before the petition would be heard. I read it twice. Then I called Priya. She answered on the second ring. I read her the letter. She was quiet for a moment. Then she said, "He is trying to make this permanent." "I know." I said, she said, "How long have you had the timeline?" I said, 4 months. She said, "Send it to me tonight." I sent it that night. Priya spent 2 weeks reviewing the timeline and the documents I had assembled. She brought in a colleague, a probate attorney named James Whitfield, who specialized in trust disputes. James reviewed the Alderton account structure, the transfer authorization with the impossible date, and the petition Warren had filed. He called me on a Thursday evening and said, in the flat, careful tone of someone who has seen a great deal and is choosing his words precisely, that what Warren had done was, in his professional opinion, a textbook example of trustee overreach built on a foundation document of questionable authenticity. He said the financial wellness evaluation cited in the petition had been commissioned by Warren personally, conducted by a firm called Clarity Financial Assessments, and had never been disclosed to me or consented to by me. He said the credit card balance and the personal loan, both of which were fully resolved and well within normal parameters for someone in my income bracket, had been characterized in the petition in language that was, quote, selectively framed to suggest a pattern that the underlying data does not support. He said we had a strong case. He also said something I want you to hear. He said, the person who built this structure was patient and methodical and understood exactly what he was doing. He did not make mistakes. He made choices, and every choice he made is documented. That is the thing about paperwork. It cuts both ways. Stay with me. This is where it changes. James filed a response to the petition in Franklin County Probate Court on March 9th, 2020. The response included 4 attachments. First, a certified copy of my mother's bank records showing no debit card or ATM activity in Columbus on August 16th, 2016, the date on the transfer authorization. Second, the restaurant receipt from the Ivory Fork in Cincinnati, time-stamped 6:47 p.m. on August 16th, 2016, showing a transaction on my debit card. Third, a statement from my mother's college roommate, obtained by Priya, confirming that Claudia and I had visited her in Cincinnati on that date and had not left until after 8 p.m. Fourth, a forensic document analysis of the transfer authorization, conducted by a certified document examiner, concluding with a high degree of professional certainty that the signature on the authorization, while resembling Claudia Voss's signature, showed specific inconsistencies in pen pressure and letter formation that were inconsistent with her other authenticated signatures from the same period. The examiner's report used the word inconsistent 4 times. In forensic document work, inconsistent is the polite word for what a jury would call something else. We also filed a separate motion requesting that the Clarity Financial Assessments evaluation be excluded from the petition on the grounds that it had been commissioned without the beneficiary's knowledge or consent and had never been disclosed as required under Ohio trust law. James said the exclusion motion was almost certain to succeed. He was right. The evaluation was excluded 11 days later. The petition hearing was scheduled for April 22nd, 2020. I want to tell you what happened in the 3 weeks between the response filing and the hearing, because those 3 weeks are where the family part of this story lives, and the family part is harder than the legal part. Warren called me 2 days after the response was filed. I did not answer. He left a voicemail. His voice was exactly as it always was, calm, measured, a little concerned. He said he was sorry I had felt the need to involve attorneys, that this was a family matter, that he had always acted in my best interests, and that he hoped we could sit down and talk before things went any further. He said he loved me like a daughter. He said that word, daughter. I saved the voicemail. My mother called the following evening. Her voice was different from Warren's. It had the quality I had learned to recognize over the years, the quality of someone who is frightened and does not know which direction the danger is coming from. She said, Renata, what is happening? I said, Mom, I need to ask you something, and I need you to answer me honestly. Did you sign a document in August of 2016 authorizing the transfer of my custodial account to a firm in Cincinnati? She was quiet for a long moment. Then she said, I don't think so. I said, do you remember that Saturday we drove to Cincinnati to see Deborah after her knee surgery? She said, of course. I said, we were gone all day. We had dinner at that restaurant on Montgomery Road. She said, yes. I said, Mom, the transfer authorization is dated that Saturday. She did not say anything for a long time. I could hear the kitchen clock in the background, the same clock that had been on that wall since I was 9 years old. Then she said, in a voice that was very quiet and very careful, I think I need to talk to someone. I said, I think that would be a good idea. I gave her James Whitfield's number. She called him. The next morning, my mother's conversation with James lasted 2 hours. I was not present for it. James told me afterward that she had been cooperative, precise, and, in his words, clearly, someone who had been managing a great deal of information for a long time and had finally found a place to put it down. She told him that she had signed documents for Warren over the years without always reading them carefully, that she had trusted him with the financial administration of the household, and that she had not known the custodial account had been restructured until I had asked her about it the previous year. She also told him something I had not known. She told him that Warren had, on 2 separate occasions in 2018 and 2019, asked her to sign documents that she described as estate planning paperwork, and that, on both occasions, she had signed without reading them fully. James requested copies of those documents. She found them in the filing cabinet in the study, in a folder labeled Household Legal, behind the electric bills. She brought them to his office the following week. One of them was a durable power of attorney, signed by my mother, granting Warren broad authority to act on her behalf in financial and legal matters. The other was an amendment to the Alderton Trust Agreement that expanded the trustee's discretionary authority and added a provision allowing the trustee to petition for extension of the discretionary period based on the trustee's assessment of the beneficiary's financial fitness. My mother had signed both documents. She had not known what either of them said. The power of attorney was dated November of 2018. The trust amendment was dated March of 2019, 6 months before Warren had moved to extend the trust. He had built the legal foundation before he laid the floor. That is the kind of patience that takes years to recognize and seconds to understand once you see it. I drove to Westerville the Saturday before the hearing, not to confront anyone, not to give a speech. I went to see my mother. I sat at the kitchen table on Aldermore Lane, the same table where she had told me about my father's account when I was 12, and I put a folder on the table between us. Not the blue folder. My folder. My Foterstone. Inside, it was the timeline, the restaurant receipt, the bank records, the document examiner's report, and a one-page summary that James had prepared showing the sequence of events from 2016 to the present. I did not read it to her. I slid it across the table and let her read it herself. She read it slowly. She turned each page carefully, the way she used to turn the pages of the books she read to me when I was small. When she finished, she closed the folder and put her hands flat on top of it. She did not say she was sorry. She did not say she had not known. She said, I should have read the documents. That was all. 4 words. I should have read the documents. It was not an apology. It was an accounting. And from my mother, in that moment, it was the most honest thing she could have offered. I said, I know. I picked up the folder. I drove back to Columbus. The hearing on April 22nd, 2020 was not dramatic. Probate hearings rarely are. The courtroom was small, wood-paneled, and smelled like old carpet and recycled air. Warren sat at the respondent's table in a gray suit with his attorney, a man named Philip Crane, who had the practiced calm of someone who had spent 30 years in courtrooms and had learned to make everything sound reasonable. James sat beside me at the petitioner's table. My mother sat in the gallery. She had come without Warren. He had not known she was going to be there until she walked in. I saw his face when she sat down on my side of the room. It was the only moment in the entire proceeding where his composure shifted just for a second. The way a level shifts when the surface underneath it is not quite flat. The judge was a woman named Judge Carolyn Merritt, 61 years old, 23 years on the bench. She reviewed the filings before the hearing and had clearly read them carefully because her questions were precise and she did not need anything explained twice. James presented the timeline, the restaurant receipt, the bank records, and the document examiner's report. He presented my mother's statement. He presented the Clarity Financial Assessments exclusion. He presented my professional credentials, my CPA license, my employment record, my credit score of 794, my zero outstanding debt as of the filing date. He presented the original custodial agreement from the credit union, which contained no discretionary provision, no extension clause, and no trustee authority beyond basic custodial management. He said the beneficiary was 25 years old. The original instrument required transfer. The transfer did not occur. The reason it did not occur is documented in these filings. Philip Crane argued that Warren had acted in good faith, that the restructuring had been intended to protect the asset, that the transfer authorization had been signed by the custodian. Judge Merritt asked him one question. She said, "Can you explain the discrepancy between the date on the authorization and the beneficiary's evidence that the custodian was in Cincinnati on that date. Philip Crane said he could not explain it at this time, but would need additional time to investigate. Judge Merritt said she did not think additional time was warranted. She ruled from the bench. The petition to extend the discretionary period was denied. The Alderton trust structure was ordered dissolved. The account balance, $68,400, was to be transferred to my sole account within 15 business days. She also referred the matter of the transfer authorization to the Franklin County District Attorney's Office for review of potential document fraud. She said this without inflection, the way you note a discrepancy in a ledger. Matter of fact. Documented. On the record. Warren did not look at me when the ruling was read. He looked at the table in front of him, his hands flat on the surface, the same posture he had used at every dinner table and church lobby and family gathering for 26 years, the posture of a man who is always the most reasonable person in the room. Except this time, the room had a judge and a document examiner, and a restaurant receipt from Cincinnati, and reasonable was not enough. I did not feel triumphant. I want to be honest about that. I felt the specific exhaustion of someone who has been carrying a weight for a long time and has finally set it down, not because the journey is over, but because the weight was never theirs to carry. I picked up my folder. I thanked James. I walked out of the courtroom. My mother was waiting in the hallway. She looked at me for a moment. Then she said, "I kept the report." I said, "I know." She said, "Dr. Marsh's report from 2002. I kept it in the blue folder because I wanted you to have it someday. I wanted you to know that someone had looked at you carefully and seen exactly what was there." I said, "I know, Mom. I found it when I was 23. She nodded. She did not try to hug me. She understood that we were not there yet. She turned and walked toward the elevator. I walked toward the stairs. Some distances close slowly, if they close at all. I want to tell you what happened in the months after the hearing, because the legal resolution is not the end of the story. The end of the story is smaller and truer than that. The Franklin County District Attorney's Office reviewed the referral and declined to prosecute. Warren had no prior record. The financial harm had been remedied through the civil proceeding. The document examiner's report established inconsistency, but not certainty. And certainty is what a criminal prosecution requires. The assistant district attorney, who called me, explained this in the careful, slightly apologetic tone of someone who understands that the law and justice are not always the same room. I understood. I had not filed the civil action, expecting a criminal conviction. I had filed it to dissolve a structure that should never have been built. The structure was dissolved. The record of how it was built exists in the Franklin County probate court filings. Public record, available to anyone who looks. If Warren ever tries to build something similar again, the blueprint is on file. That was enough. The $68,400 transferred to my account on May 12th, 2020. I sat with the transfer confirmation on my laptop for a long time. $50,000 from my father, who died when I was 4 years old, who smelled like sawdust and something citrus, who I have 3 photographs of, and a feeling more than a memory. 22 years of growth. I thought about what to do with it for 3 weeks. Then I did 2 things. First, I opened a dedicated savings account and transferred the entire amount into it. I labeled it Marcus, not as a shrine, As an acknowledgement, he left me something. It arrived late, but it arrived. Second, I called my firm and asked to take on a pro bono case that had been sitting on the intake list for 4 months. A woman in her 60s whose son had restructured her assets without her knowledge. She did not have the resources to hire a forensic accountant. She needed someone who could read what the documents were trying not to say. I took the case. I have taken 11 more like it since then. That is not heroism. That is just knowing what your skills are for. Priya and I had dinner the week after the transfer confirmed. Her apartment, the same table where I had told her about the clause in October of 2019. She opened a bottle of wine she had been saving for something. She said, "I want to ask you something, and I want you to answer honestly." I said, "Okay," she said. "Are you all right?" "Not legally." "I too." "Not financially." "Are you all right?" I thought about it for a moment. I said, "I think I am becoming all right." That is different from being all right. But it is the direction. She said, "That is the most forensic accountant answer I have ever heard." I said, "I have been told I have a gift for reading what a document is trying not to say." She laughed. I laughed. It was the first time I had laughed about any of it. It felt like something releasing that had been held for a very long time. I want to tell you about Elliot, because Elliot is the part of this story I have not resolved, and may never fully resolve. He is 25 now. He is in graduate school in Ann Arbor, studying environmental engineering. He is, by every measure I have, a good person. He grew up in a different house than I did. Same address, different experience. Warren was his father, fully and without complication. The man who coached his soccer team and drove him to school and sat in the front row at his high school graduation. Elliot did not know about the account. He did not know about the transfer authorization or the Alderton structure or the petition. He found out the way most people in our family found out, through the slow, uncomfortable spread of information that happens after a legal proceeding becomes public record. He called me in June of 2020. He said, "I don't know what to say." I said, "You don't have to say anything." He said, "I am sorry." I said, "You didn't do anything." He said, "I know, but I am still sorry." We talked for 40 minutes. It was the longest conversation we had ever had. At the end of it, he said, "Can I call you again sometime?" I said, "Yes." He has called 4 times. Since then, we are figuring out what we are to each other, which is something neither of us has a template for. I think we will get there. I think it will take a while. How some distances, close, slowly. My mother and Warren separated in August of 2020. She did not call it a separation at first. She called it a period of reflection. By November, she had moved into an apartment near Margine's house, and by the following spring, she had filed for divorce. I did not ask her to do any of that. I did not encourage it or discourage it. She made those decisions in the specific privacy of her own understanding, which arrived on its own schedule. She calls me on Sundays. Now, not every Sunday. Most Sundays. We talk about her job. She went back to dental hygiene at 61, about Elliot's research, about what I am reading. We do not talk about Warren. We do not talk about the account, or the hearing, or the blue folder. We are building something new on ground that was cleared the hard way. It is slow work. It is the right work. I went back to Westerville for my mother's birthday in October of 2021, a Saturday, just the two of us and Elliot, who drove down from Ann Arbor. We ate dinner at the kitchen table on Aldermore Lane. My mother had made the same pasta she used to make when I was small, the one with the lemon and the capers that I had always asked for on birthdays. After dinner, she went to the study and came back with the blue folder. She set it on the table in front of me. I opened it. The immunization records, the identification records, the report cards, HOUDs, the social security card in the paper sleeve. And at the back, Dr. Elaine Marsh's report from October of 2002. Highly functioning, strong, verbal reasoning, above average capacity for abstract problem solving, exceptionally self directed for her age. My mother had kept it for 19 years. She had kept it the way you keep a deed, proof that something belongs to someone, proof that the name on the document is the right name. I read it at the kitchen table, the same table where she had told me about my father's account when I was 12, the same table where I had sat with my folder the Saturday before the hearing, the same table where, 23 years earlier, a 4-year-old girl had eaten breakfast while her mother quietly filed the first piece of evidence. I folded the report. I put it back in the blue folder. I kept the folder. My mother nodded when I took it. She did not say anything. She did not need to. The folder had always been mine. It had just been waiting for me to be ready to carry it. I have thought a lot about what Warren understood that the rest of us did not. He understood that the most effective way to control someone is not to take things from them directly. It is to build structures that make it look like they gave things away. He understood that a narrative of concern is harder to fight than a narrative of cruelty, because concern sounds like love and cruelty sounds like what it is. He understood that paperwork is patient in a way that people are not, that a document filed in 2016 will still be doing its work in 2020 if no one looks at it carefully enough. What he did not understand, what he could not have anticipated, is that the child he had tried to have evaluated at 8 years old for being too intense, too focused, too much in her own head, would grow up to spend her professional life reading documents that were written to be misread. He built his structure in the dark. He did not know I had a flashlight. He did not know I had been building one since I was 22 years old, one reconciled balance sheet at a time. Dr. Marsh's report said I was exceptionally self-directed for my age. Warren had taken me to that appointment, hoping to find something wrong. What he found, what my mother kept in a blue folder for 19 years, was a document that said I was exactly what I needed to be. He had tried to use that appointment to build a case against me. My mother had used it to build a case for me. The difference between those two uses of the same document is the difference between the two people who raised me. One of them kept the record. One of them tried to rewrite it. I know which one I became. I know which one I am. My name is Renata Voss. I am 31 years old. I am a forensic accountant. I read what documents are trying not to say, and the most important document I have ever read was a 1-page report from a child psychologist, filed in a blue folder in a roll-top desk on Aldermore Lane, that said I was fine, that I had always been fine, that the person who told you otherwise was the one who needed to be evaluated. If this story reminded you that your name is yours, that no one gets to sign it but you, that the records you keep quietly in the second drawer are sometimes the most important records you will ever have. Do me a favor. Share this with someone who is still waiting for permission to trust what they already know. Thank you for being here. Drop, comment, subscribe, into, and I will see you in the next one.